And breaking overnight, CNN got word that a key attorney to Donald Trump turned critical witness has left his legal team. Evan Corcoran was hired to help Trump in the classified documents case, but he became a central part of the very indictment because of the meticulous notes and memos he took about his interactions with Trump. The indictment referred to Corcoran as Trump Attorney 1 at least 20 times, and it was from Corcoran's notes and memos that we learned that Trump allegedly misled him about the whereabouts of the classified documents, encouraged him to lie to the Justice Department and withhold these documents allegedly. If the case ever goes to trial, prosecutors could potentially call Corcoran as a key witness. And this morning, we know he is out of the fold, and as Maggie Haberman told us overnight, that is disquieting to Donald Trump.
What's up? People welcome Adam is here, so this has just happened. In a sealed proceeding only recently made public, a federal prosecutor abandoned measured legal language and told the court plainly, not alleged crimes, not potential violations, but crimes committed by a former president, proven by notes taken by his own attorney. Let me reconstruct the architecture of this thing from the ground up, because every layer reveals something more disturbing than the last.
Special counsel Jack Smith has charged the former president with trying to overturn the results of the 2020 election and obstruct the certification of the electoral vote, which culminated with the January 6th attack on the U.S. Capitol.
It really is extraordinary that those who are close to Trump and who are providing him with legal counsel and political counsel are now accepting that they committed criminal wrongdoing and are testifying under oath against him.
Loyola Law School professor Jessica Levinson says Mr. Trump is facing serious legal jeopardy. The former president has been charged with 91 felony counts in 4 criminal cases and a civil fraud suit in New York that threatens to upend his business empire.
Michael, can you say a couple words here?
The investigation into classified documents had been grinding forward for months by the time this hearing was convened. Federal agents had already executed a search at Mar-a-Lago, that gilded fortress on the Florida coast where the former president had decamped after leaving office with boxes upon boxes of materials that did not belong to him. The initial response from Trump's team had been smooth and confident. They had cooperated fully. They had returned everything.
Damning new details in the Trump classified documents probe. The Guardian's reporting Trump's lawyer was, quote, waved off from searching Trump's office for records, which was later where the FBI found the most sensitive materials. Noting several Trump aides told this lawyer, Evan Corcoran, to search the storage room where he found 38 classified documents. Corcoran then asked whether he should search anywhere else, but was steered away. I want to note that a Trump spokesperson denied that allegation, but we already know Special Counsel Jack Smith has been eyeing obstruction charges, and that does not look good for Donald Trump. New reports also depicting chaos on Trump's legal team. The Daily Beast reporting Trump's lawyers are starting to wonder if there might be a snitch. When is that? Snitches get stitches. One member of his legal team saying, quote, there's a lot of lawyers and a lot of jealousy. I wrote a piece on this for MSNBC.com, and I pointed out, quote, with Trump, you have the perfect storm of infighting lawyers jostling for pole position and a client who's prone to embracing the microphone and never meeting a camera he didn't love. I concluded, quote, it's a recipe for an attorney-client disaster.
There was nothing to see here, and certainly nothing to prosecute, but investigators had reason to believe otherwise, and their suspicions had led them to Evan Corcoran, an attorney with serious credentials who had been brought into the inner circle to navigate the legal peril that was rapidly enveloping his client. Corcoran had done what lawyers do. He had taken notes, detailed notes, notes about conversations, notes about instructions, notes about exactly what his client was telling him to do with the sensitive materials that were still sitting somewhere they were not supposed to be. The defense strategy was obvious and, in most circumstances, entirely proper. Those notes were protected by attorney-client privilege, the ancient legal doctrine that shields communications between a lawyer and a client from compelled disclosure. The privilege is sacrosanct for good reason. A legal system cannot function if clients are afraid to speak candidly with their attorneys. If every whispered concern and every hypothetical question could end up in the hands of prosecutors, the adversarial process would collapse into a farce where defendants navigate the system blindfolded. The privilege is a bedrock principle, and judges are appropriately reluctant to breach it. But the privilege has always carried an exception, a narrow but critically important carve-out that exists for precisely the situation the prosecutor believed he was facing. If a client is using their lawyer not to seek legitimate legal advice but to further a crime, the privilege evaporates. You cannot hire an attorney, explain your criminal scheme to them, ask them to help you execute it, and then shield the entire conspiracy behind a claim of confidentiality. The crime-fraud exception exists because the law recognizes that there is a boundary between defending a client and joining their criminal enterprise. And when that boundary is crossed, the protections of the legal profession fall away. The prosecutor stood up in that sealed hearing and made the case that the boundary had not just been crossed, it had been obliterated. The communications between Trump and Corcoran, he argued, were not a client asking for guidance on compliance with the law. They were not a client wondering whether certain actions might be legally permissible. They were a client issuing directives about how to hide evidence, how to delete materials, how to construct false narratives for investigators. The notes allegedly captured Trump telling his lawyer to make things disappear, to move things around, to tell the government things that were not true. If the allegations were accurate, and the prosecutor obviously believed they were, then Corcoran had been transformed from a legal advisor into an instrument of obstruction. The crime-fraud exception was not a theoretical possibility. It was the precise mechanism the law had designed for this exact scenario. The judge presiding over this hearing was Beryl Howell, a federal jurist sitting in Washington who had seen more than her share of high-stakes litigation and who was not known for being easily swayed by theatrical arguments. She listened to the prosecutor lay out the evidence. She reviewed the materials that had been submitted under seal, and then, in a ruling that sent shockwaves through the legal team defending Trump, she agreed. The crime-fraud exception applied. The privilege shield was gone. Corcoran had to testify. The notes had to be turned over. More than 100 pages of communications that Trump had assumed would remain confidential forever were suddenly fair game, and the contents of those pages, when they began to surface, painted a picture of direct, knowing, willful obstruction directed by the person at the very top of the organizational chart. The specific allegation that emerged from this legal earthquake is as straightforward as it is damning. Trump did not stumble into possession of classified materials by accident, and then bumble through a series of misunderstandings about what he was supposed to return. He knew what he had. He knew he was not supposed to have it. And when the government came asking for it back, he allegedly looked at his lawyer and gave instructions designed to prevent the government from ever finding out the full extent of what was hidden away. Delete this, move that, tell them we already gave them everything. The notes allegedly captured these directives in real time, the client telling the lawyer what to do, the lawyer writing it down, the paper trail that would eventually become the most dangerous evidence in the entire investigation. The consciousness of guilt embedded in those communications is the kind of thing that prosecutors dream about. It is not circumstantial. It is not inferential. It is direct evidence of a state of mind that knew the conduct was criminal and chose to conceal it anyway. The contrast with the public posture that Trump maintained throughout this period is so stark that it almost functions as its own form of incrimination. While he was telling the world that he had done nothing wrong, that the investigation was a witch hunt, that the FBI was persecuting him for political reasons, the notes allegedly show him doing exactly what an innocent person would never need to do. Innocent people do not delete evidence. Innocent people do not tell their lawyers to mislead federal agents. Innocent people do not orchestrate cover-ups. The public narrative and the private conduct existed in completely separate universes, and the unsealing of the hearing transcript forced those universes to collide in the most damaging way possible. The drama of the hearing itself deserves to be understood as more than just a procedural milestone. The prosecutor was not merely arguing a legal standard or citing precedents to a skeptical bench. He was, by all accounts, visibly furious. The carefully maintained composure that federal prosecutors typically project, the calm rationality that signals confidence in the strength of the case, gave way to something more visceral. He had reviewed the evidence, he had seen the notes, he had understood exactly what they meant. and he was standing in a courtroom asking a judge to recognize that the former president had used his own attorney to commit crimes. The language he used was not hedged with qualifiers and caveats. It was direct, declarative, and unambiguous. The communications were in furtherance of crimes including obstruction, not maybe crimes, not possibly crimes, crimes. The word landed in the courtroom like a hammer blow, and it has been echoing ever since the transcript was pried open to public view. The timing of the unsealing could not have been more consequential. The hearing itself happened during the earlier phase of the investigation, when the special counsel was building the case and the legal machinery was grinding forward with the momentum that precedes an indictment. Then the case got tangled in procedural delays, in the controversial rulings of a Florida judge who seemed determined to slow everything to a crawl, in the political complications of a presidential campaign that elevated the defendant back to the highest office in the land. The classified documents case faded from the headlines, replaced by other scandals and other crises, and the public largely forgot that there were sealed transcripts sitting in a courthouse vault containing explosive allegations that had never been fully aired. Then the transcripts were unsealed, and the forgetting stopped. The political dimension of this moment is inescapable because it strikes at the very core of the identity that Trump has constructed over decades in public life. He is the law and order candidate. He is the one who chants about locking up opponents. He is the one who campaigned on a promise to restore accountability to a system he claimed had been corrupted by elites who never faced consequences. The footage exists from rally after rally, the crowd roaring as he led them in calls for Hillary Clinton's prosecution, the podium pounding as he demanded that someone finally hold the powerful to account. That was the brand. That was the sales pitch. And now, here in black and white in a federal court transcript, is a prosecutor describing how the man who built that brand allegedly obstructed justice, allegedly hid evidence, allegedly directed his own lawyer to lie to the government. The hypocrisy is not subtle. It is not a matter of interpretation. It is a canyon between what he demanded of others and what he allegedly did himself. The constitutional paradox that this situation creates is genuinely novel. Trump is now president again. The Department of Justice is part of the executive branch he controls. His hand-picked Attorney General, Pam Bondi, took an oath to uphold the Constitution and administer justice fairly. But she also serves at the pleasure of a president who has made abundantly clear that he views the DOJ as an instrument of personal protection rather than an independent arbiter of the law. The evidence of potential crime sits inside the department that reports to the person who allegedly committed them. The notes are there. The prosecutor's arguments are there. The judge's ruling is there. The question of what happens next is not a hypothetical, because the answer will define whether the American system has any remaining capacity to hold its most powerful figure to account. If the department moves forward, if it takes the evidence that a federal judge found credible and pursues the obstruction case to its logical conclusion, the nation enters uncharted constitutional territory. A sitting president under active criminal investigation by his own Justice Department, potentially facing charges while occupying the office that commands the FBI agents who would investigate him, is a scenario the framers never contemplated and the legal system has never had to navigate. The conflicts of interest are innumerable. The political explosion would be thermonuclear. But the alternative is arguably worse. If the department does nothing, if the evidence sits in a drawer while the president continues to govern, the message is unmistakable. The occupant of the Oval Office is above the law. The crime-fraud exception applies to everyone except the person who appoints the Attorney General. The sacred principle of equal justice under law becomes a hollow phrase that applies only to the powerless. The internal dynamics at the Justice Department must be absolutely fraught right now. Career prosecutors who have spent their professional lives building cases against obstruction and cover-ups are looking at a mountain of evidence implicating their ultimate boss. They took oaths to the Constitution, not to any individual president, and the tension between their professional obligations and the political reality of who signs their paychecks is almost unbearable. Some of them have already left, resigning rather than participating in what they viewed as the degradation of the institution. The ones who remain are facing a choice that no prosecutor should ever have to face. Do they push forward, risking their careers and potentially their personal safety, or do they acquiesce to a reality where the rules apply selectively and the most powerful person in the country gets a permanent pass? The significance of Judge Howell's role in this saga cannot be overstated. She is not a political figure. She is not an elected official who has to worry about the next primary challenge. She is a federal judge with a lifetime appointment and a professional reputation, built on applying the law to the facts without regard to the identities of the parties before her. When she reviewed the sealed materials and concluded that the crime-fraud exception applied, she was making a legal determination based on evidence. She was not opining on Trump's fitness for office or commenting on the political implications of her ruling. She was doing what judges are supposed to do, and what she found was that a prosecutor had presented sufficient evidence to pierce one of the most protected privileges in American law. That finding deserves to be weighed carefully by anyone who wants to dismiss this case as a partisan fishing expedition. Judges do not casually override attorney-client privilege. It is one of the most serious steps a court can take. The fact that she took it here signals that the evidence was not marginal or ambiguous. It was compelling. The notes themselves, those 100-plus pages of communications that Corcoran was forced to produce, are now part of the evidentiary record. Their full contents have not been publicly released, but the descriptions that have emerged from the court proceedings paint a vivid enough picture. Trump allegedly knew the classified materials were still at his property. He allegedly knew the government was asking for them. He allegedly instructed his lawyer to take actions that would prevent the government from discovering them. The instructions were not subtle suggestions or vague expressions of concern. They were, according to the prosecutor's characterization, direct orders to obstruct the investigation, delete evidence, conceal materials, mislead federal agents. The language is not the language of someone trying to comply with the law. It is the language of someone trying to evade it. The broader context of the classified documents investigation gives these revelations their full weight. The materials that Trump took to Mar-a-Lago were not old newspaper clippings or personal correspondence. They were classified documents, some of them at the highest levels of sensitivity, containing information about national defense, about intelligence sources and methods, about the kinds of secrets that can get people killed if they fall into the wrong hands. The government does not classify documents at that level casually. The classification system exists to protect lives and operations, and the people who are granted access to those materials are supposed to understand the gravity of the responsibility. Trump, having held the highest security clearance in the land, knew exactly what he had taken and exactly what the rules required. The allegation is not that he was sloppy or forgetful. It is that he was deliberate, that he knew he was not supposed to have those materials, that he knew the government wanted them back, and that he made a conscious choice to obstruct the government's efforts to retrieve them. The timeline makes the obstruction allegation even more damning. The government did not immediately raid Mar-a-Lago. It tried the cooperative approach first. It sent requests. It negotiated with Trump's team. It gave multiple opportunities for voluntary compliance. The search warrant that eventually authorized the FBI to enter the property was a last resort, obtained only after months of attempted negotiation had failed to produce the return of all the materials. If Trump had simply handed everything over when the government first asked, the investigation would likely have ended there. The obstruction that allegedly occurred during those months of negotiation is why the case became criminal in the first place. The cover-up, as it so often does, became the more serious crime than the underlying offense. The unsealing of the hearing transcript has also reignited questions about the performance of Judge Aileen Cannon, the Florida jurist who has presided over the Mar-a-Lago proceedings with a pace and temperament that have drawn widespread criticism from legal observers. Cannon has been accused of slow-walking the case, of issuing rulings that seem designed to delay rather than resolve, of treating the defense arguments with a solicitude that appeared to go beyond normal judicial patience. Her handling of the case has been contrasted sharply with Howell's decisive ruling on the crime-fraud exception. Two federal judges, both looking at evidence related to the same underlying conduct, reaching very different conclusions about how urgently the legal system needed to act. The discrepancy has fueled ongoing debate about whether the judiciary can maintain its institutional integrity when the cases before it involve political figures who can influence public perception of the courts. The public reaction to the unsealing has followed the familiar grooves that every Trump scandal eventually carves. His supporters dismiss the proceedings as another front in the deep state conspiracy, another desperate attempt by the establishment to take down a president who threatens their power. His detractors see in the transcript the long-awaited proof of what they always believed, that the man who campaigned on law and order is himself a lawbreaker who has escaped accountability through a combination of legal obstruction and political intimidation. The middle ground, the people who do not follow every twist of every court filing, are caught in the exhausting position of trying to determine whether the latest bombshell is truly as significant as the headlines claim, or whether it will fade like all the previous bombshells that somehow failed to detonate on impact. But this one feels different, and the reason it feels different is the source of the allegations. This is not a former business associate telling a story to a magazine. This is not an anonymous leak from a disgruntled staffer. This is a federal prosecutor standing in a federal courtroom, addressing a federal judge, arguing that the evidence he has reviewed shows the former president using his own lawyer to commit crimes, and the federal judge agreed. The crime-fraud exception applied. The privilege was pierced. The notes were turned over. That chain of events is not rumor or speculation. It is a matter of court record, unsealed and available for anyone to read. The question of what happens next is not about whether the allegations are real. It is about whether anyone in a position of authority has the will to act on them. The broader historical significance of this moment extends far beyond the fate of one individual. The American experiment is built on the premise that no person, no matter how powerful, stands above the law. The founders had just fought a revolution against a monarch who claimed precisely that privilege, and they designed a system intended to prevent its re-emergence on American soil. The crime-fraud exception is a direct descendant of that founding principle. It says that even the most sacred protections of the legal system have limits, and those limits are reached when the protections are being used to facilitate crime. If the exception can be invoked against every defendant except the one who occupies the White House, then the principle is dead, and the monarchy the founders fought to escape has been rebuilt under a different name. The prosecutor who stood up in that sealed hearing and made his case with such evident fury understood exactly what was at stake. He was not just arguing about the admissibility of a set of notes. He was arguing about whether the legal system would apply its rules equally, or whether it would carve out a special exemption for a defendant too powerful to touch. He won that argument in Judge Howell's courtroom. He convinced a federal judge that the evidence was sufficient to override one of the most jealously guarded privileges in American jurisprudence. Now the question is whether the victory will mean anything, or whether it will be buried by an administration that controls the very department tasked with enforcing the law. The transcript is unsealed. The words are public. The fury is preserved for history. What remains to be seen is whether anything follows from it.